Welcome, everyone, to today's AHLA podcast, where we'll be talking about key trends and developments under the physician self-referral law, often referred to as the Stark Law. I think many of us have heard that quote by Troy Barsky that the Stark Law is a tortured web of confusing standards from his time when he was, he's a former director of Division of Technical Payment Policy at CMS. And it is a technical law, but I do think there are ways to find themes and ways to provide some clarity by talking about it. There's a lot we could cover in today's podcast on the Stark Law. Things like trends, new updates and interpretations, some flexibilities and enforcement priorities. And our hope today is that you leave with just a better understanding of this law, that we hopefully will help untangle some of that web that Troy was referring to. My guest today is Charles Oppenheim, and he and I are going to pick a few topics from that list to focus on today. I'm sure his name sounds familiar to most of you. He's well respected in the fraud and abuse space. He recently authored a supplement to the sixth edition of the AHLA's guide titled The Stark Law Comprehensive Analysis and Practical Guide, along with Ben Dury and Amy Joseph. Today's podcast is brought to you by the American Health Law Association's Fraud and Abuse Practice Group. I currently chair the practice group, and our mission is to help our members stay informed about healthcare fraud and abuse and compliance issues. We're getting ready to wrap up another program year, and our vice chairs are doing a great job of developing webinars, publications, and other content to educate our members. Before we get into the kind of back and forth here, Charles, why don't you go ahead and introduce yourself?
Thanks, Joe. So my name is Charles Oppenheim, and I'm a partner in the law firm of Hooper, Lundy Bookman. I'm located in Los Angeles and San Francisco offices of HLB, and I'm a transactional healthcare lawyer. I've been doing healthcare law for more than 30 years. And in particular, one of my signature issues is kind of the anti-kickback statute and the Stark Law. And I wrote the book that Joe referenced on the Stark Law. I wrote the first edition all the way back in 1998. And then every few years we update it, most recently with the seventh edition, and then even more recently with the supplement to the seventh edition. And I'm sure Stark aficionados are on the edge of their seat waiting for the eighth edition, which will be the next one out. That'll be in another year or two. The Stark Law evolves. So, every few years there's, a need to kind of update the information that's available out there. Thanks, Joe.
Yeah, thanks, Charles. I guess that shows, I think I referenced the sixth edition in the intro, and I need to run out and get the seventh. So appreciate that. And then I'm Joe Wolfe. I chair the Fraud and Abuse Practice Group for the American Health Law Association. I'm a shareholder at Hall Render, and I lead Hall Render's Health Regulatory Practice Group. And like Charles, focus a lot of my practice on Stark and kickback. I think Charles and I presented maybe the first time 10 years ago or so. And it's good to be back together. Just starting off a bit of level setting, when we think about the Stark Law, for the listeners that aren't that familiar with the law, again, the Stark Law is another name for the physician self-referral law. This is a law, Charles mentioned, the first edition of the book was back in 1998. This law has been around for a while now. It was enacted to address policy concerns that when a healthcare organization, let's say a hospital or a medical group, has a financial arrangement with a referring physician, that arrangement might inappropriately influence the physician's medical decision-making, cause patient steering, or perhaps overutilization under the Medicare program. So the Stark Law framework says that if there is essentially a referral and billing prohibition. So essentially that means that when you have that financial arrangement and it's present between the entity, again, let's say a hospital or a medical group, and the referring physician, then the physician can't make a referral for certain kinds of designated health services, like inpatient or outpatient hospital services, for example, and the entity can't submit claims for the inappropriately referred services. So that's how the law works. And so if you have that financial arrangement, it's supposed to meet a Stark exception. And so a lot of my work and a lot of what Charles does is analyzing whether or not arrangements meet a Stark exception. and one, analyze whether Stark applies. If it does apply, how does the analysis work under a Stark exception? There are a lot of Stark exceptions. There are over 30 of them. If you look just at the compensation exceptions alone found in 411.357 of the regulations, we're up to BB in the regulations. So, I mean, that means there's 28 just in that part of the regulations alone. When you do this kind of analysis, what's critical is that you kind of work through in sequence. Do you have a physician? Do you have an entity? Is there a financial relationship? Is there a referral being made from the physician to the entity? Are there designated health services in the mix? Is it payable under Medicare or perhaps Medicaid too? And so there's a lot to unpack there, and that's why looking at a resource like Charles has developed and his team is so important. As he alluded to, there have been iterations of that book, but when we look at the history of Stark, it has had a very complex rollout over time. It's incremental and it's a bit complex over time, and you have to look at the rules that were in effect at the time. So if you're kind of new to Stark, you're going to start hearing about the importance of a more granular review of the Federal Register and about the different iterations called Stark 1 or Stark 2, and then Phase 1, 2, 3, and the regulatory sprint. Those will be words you get very familiar with. And that last one is really important. Back in 2021, some new regulations went into effect that we often refer to as a regulatory sprint that reformed Stark. Notably, it made the law more flexible. It also clarified the big three of fair market value, commercially reasonable, and the volume or value standard. It rolled out the new Stark value-based enterprise framework. And those are some of the big items that have taken place, again, since these new rules went into effect. So again, the goal here was to level set. And now Charles and I are going to have some back and forth about practicing in this space, what those rule changes mean, and just hopefully give you some practical guidance on how to interpret this law. So I'll start off with a question for Charles. Charles, you mentioned earlier your practice has largely focused on Stark over the years. If you're thinking about someone new to healthcare, how do you recommend that they get their arms around the law and the complexity that we were just alluding to?
No, that's a great question, Joe. I think for the person who's new to the area, I think the initial idea would really just be to familiarize yourself, so you kind of have the ability to do some issue spotting. There are some introductory materials available. CMS has a website dedicated to the Stark law. The government doesn't call it Stark. They usually call it the Federal Physician Self-Referral Law. But so CMS has a website. The OIG has compliance guidance, and they mention the Stark law, again, just in a cursory way, but enough to kind of give the beginner kind of a little bit of a heads up. And there are articles and other things out there, if you do some Google research, that will give you a little bit of an intro. If you have the good fortune to be at a firm where there are lawyers who are experienced practitioners in the area, one of the best ways is just to sit down with them for a few minutes and ask them to give you an overview and an introduction. I mean, like Joe just gave us, if you're new to the Stark area, just like a very high level. And as an introductory matter, you probably want to approach fact patterns kind of with almost like a checklist in mind, like Joe mentioned, like, is there an ownership or a compensation arrangement between the physician and the entity? Is the physician making referrals of designated health services? And have a list in case you haven't memorized the 10 designated health services and such and so on. And but approach Stark analysis, I think, with great care. It is very convoluted, and there have been decades of regulatory analysis, and the regulatory pendulum has swung back and forth, with CMS trying to tighten the screws and then loosening the rules. And so it goes back and forth, but notwithstanding that, there are things that they said in the regulations even 20 or 25 years ago that haven't been overruled and are still valid. You can rely on them. But there's also a lot in there that has been overruled. So unless you're really familiar with it, or you go through all of the regulations in order, it's not hard to kind of get lost in the woods. So issue spotting is kind of your first step as a beginner, but it's pretty daunting to take on a complicated Stark analysis if you're new to the area. I guess, so I've talked a little bit about how to get into it if you're new to the area, but Joe, I wonder if you have suggestions or thoughts to people who are more veterans. Like, what are your practice tips for them? What do you see as kind of like the big picture trends at the moment?
Yeah, thanks, Charles. I would say to even those that have practiced for a while that I think it is really important to get a good grasp of these recent rule changes to make sure you're not just advising like things have always been. If you do that, I think you'll come up with conclusions that situations are potentially non-compliant when the new rules provide a lot more flexibility. We've even seen where self-disclosures that were, placed in the disclosure protocol, the government comes back and says, have you looked at these, new rule changes since these were submitted? So I think for a person who's practicing the space, get some familiarity with the new rules. In this most recent iteration with the regulatory sprint, I think the government, CMS did a good job of rehashing where we've been and where we are now. That was really the case under the big three. The government kind of discussed some of the historical thinking on fair market value, how extenuating circumstances are important, with commercial reasonableness, how the new definition would be interpreted, and similarly, the volume or value standard. The government also gave lots of good examples in that part of the commentary and also in others like the value-based enterprise rules. And I think our healthcare clients and those working in the space can kind of compare their scenarios with some of those examples as they analyze these arrangements. I think along those lines too, the new value-based enterprise rules, getting your arms around that and how they sort of fit in the Stark toolbox is important. You might have models that include or could include incentives for things like care coordination, quality, control of cost to a payer, or that are sort of transitional models that are moving us from volume towards value. And so understanding how they fit within the toolbox is going to be really important. And it is really hard to stay on top of these changes. So, if you're not in the weeds on this, I would recommend even somebody that's been practicing a while to try to take a look at these rules again, or to bounce ideas off of somebody who's a little closer to them. Try to find resources interpreting the rule changes as well, because I think it's really important. Kind of Charles, the 2021 changes, I hit on it a little bit more earlier regarding flexibility. Those rule changes provided some flexibility. Can you give us some examples of practical applications of those rule changes?
Yeah, I think absolutely. So one of the things is, Stark has exceptions that are designed to allow referrals to continue for designated health services, notwithstanding financial relationship. And as Joe mentioned, there's a lot of different exceptions in for different types of compensation arrangements, and many of them require that the compensation arrangement be memorialized in a written agreement signed by the parties. And CMS has provided greater and greater latitude over time in that particular regard. And like, for example, in the most recent regulations, they've said that your arrangement, even if it's required to be in a writing signed by the parties, can satisfy the exception as long as all of the other requirements of the exception are satisfied other than writing and signature. And then you have up to 90 days after the start of the arrangement to document it in writing and sign it. So that's an example where there's a lot of latitude. That never was the case in the old days. And clients would often have a kind of a foot fault where they needed to get an arrangement going right away. There was a desperate need, an immediate clinical need. So the doctor started doing the services. And then, there was some catch up where, you got the lawyers involved and you wrote something up and got it signed by the parties. But if it happened after the fact, you would have a technical Stark violation for a period of time between when the arrangement began and when it was signed up and documented. So that's a terrific break. There's another Another example of leniency is the sort of imperfect performance. So for years, lawyers like Joe and I struggled when clients came to us where arrangements were perfectly documented, perfect writing, perfect signed by the parties, and the exception was satisfied for a compensation arrangement, but the parties had accidentally veered off. Like, let's say you have an office lease, but the parties had forgotten to implement a CPI adjustment. And all of a sudden they were a year or two in, or even 6 months in, and they had an oopsie moment where they realized that the rent they had been collecting was the old rent. They hadn't adjusted as they were required to under the terms of the lease. And folks weren't worried that they had a Stark violation. Now CMS has said that as long as those kinds of technical bloopers occur in the course of an agreement, but they not intentionally, you're not deliberately changing things, but you just have a mistake, you can fix them during the course of the arrangement, or even up to a grace period after the arrangement ends. And if the parties at least are restored to the place where they're supposed to be under the written agreement, it's kind of a no harm, no foul. So again, these are the kinds of examples of the leniency that CMS has provided to people that are really very welcome.
That's excellent, Charles. I probably would have picked those examples as well. They have provided good flexibility.
One question I had for you, Joe, is do you see what do you see in terms of clients that have multiple complicated financial relationships where a physician may have various sources of income? Like, do you how do you view that under Stark? Do you view that a physician would potentially come within several different Stark compensation arrangements at the same time? Or do you view it as the doctor can only satisfy one at a time? Like, how do you look at those types of situations, Joe?
Thanks, Charles. It's a good question. First of all, under the Stark regulations, and as you work your way through the commentary, it does say that you only have to meet one Stark exception. So we know that that's sufficient to, I would say, protect a financial arrangement. I do think sometimes it's helpful if you think about relying on multiple exceptions. I sometimes call it a redundancy analysis. Maybe you have an employed physician, and then, under an employment arrangement, you're relying essentially on the big three, making sure that the compensation's fair market value, it's commercially reasonable, that you haven't taken into account referrals. So you might be on all squarely on fitting within that exception, and maybe that's sufficient. But if it also is natural that you could be a Stark group practice, that may allow for an additional analysis to help protect the arrangement. And beyond that, if the model is structured perhaps to align with the new value-based enterprise rules, why not, wrap that into the same analysis? It would put you in perhaps the best spot if the arrangement was ever challenged. Again, you don't have to step through more hoops, why not try to, incorporate those? I do think that's one area of answering the question. The other is, can you look at potentially kind of segments? Some of the compensation is protected under one exception, and perhaps another one could be compensated under another. I think there are opportunities to do that. I think of, what if you have an employed physician group, and your physicians are earning compensation under that employment, but what if you also have an arrangement with an IPA where the medical group or the physicians are receiving separate compensation that flows through? Could you rely on the employment exception for the core compensation, maybe the risk sharing exception for that other compensation? This also comes up sometimes in the context of ACO related distributions as well. And I think there is an opportunity to think through how those different arrangements fit together and what strategy may be available. If the services can be separated out, maybe that's an opportunity. But I think that there is, if you look back to the commentary, there was some commentary back in phase 2 of Stark where the government discussed situations where an arrangement where Stark could permit multiple agreements between a physician and an entity, as long as those individual agreements fit within an exception to the STAR clause. So I think there's an opportunity to look at that as a redundancy analysis, or if there is a discrete services, or there's some combinations of how you could do that.
Yeah, I think that makes sense. One issue I just throw out there, I guess, is something that's sometimes referred to as stacking, where you have an arrangement between a physician, let's say, in a hospital, that satisfies an exception. Maybe it's an employment agreement. Then maybe you have an on-call coverage agreement. Then you have a medical director agreement. And you may have a whole bunch of, maybe one after another, and they stack on top of each other. Each one looked at alone, may look absolutely copacetic, but that you have to also consider kind of the big picture. Like, if you add all of these things together, do you have a doctor who's working 27 hours a day? Do you have compensation that's kind of skyrocketed? So that's kind of another kind of issue to think about on the side as well.
Yeah, I agree. And I think, with all of this, it does come down to defensibility. In a straightforward way, if you're designing a model, how do you intend to ultimately defend the model? Again, back to a redundancy analysis, well, we think we could defend it this way, and we think we have a solid foundation for that, and we've documented that. We also think these alternative approaches may also be there and available as well. So, Charles, I was thinking about, we talk about kind of complexity, and we were first just focusing on Stark, but as those of us work in this space, you're not just talking about Stark when you design arrangements. You're talking about the Stark law, the kickback statute, civil monetary penalty law, state laws. How do you think about an analysis involving these different laws? Do you focus on one over another? How do you think about these multiple analyses that are often necessary?
Right. No, that's a good question, and they are often necessary. Yeah. My starting place is always under federal law is always the Stark law. And then when I've done that, I would turn to, if I'm looking at state law, the state's equivalent, which a lot of states have their own self-referral laws. And the reason is because the Stark law is kind of a strict liability concept. So if there's a financial relationship and the physician is making referrals to the entity for designated health services, you need to have an exception available to protect those referrals. And if you don't have an exception available, the referrals are prohibited, and the entity's prohibited from billing for the services performed pursuant to a prohibited referral. So that's the case regardless of intent. The parties can be pure of heart, and in fact, their arrangement could be, absolutely blessed, and perfectly legitimate. But if it doesn't satisfy a Stark exception, you're dead in the water. And so that's always my starting place, because you have to pass Stark in order to pass go and collect $200. Now, I also think that if you do satisfy Stark exceptions, I think it helps on the kickback analysis, because I think there's, and the OIG will always have a disclaimer that says there are separate laws, and just because you comply with Stark doesn't mean we're giving you a pass on the kickback statute. And I understand they have to say that. But from a practical standpoint, if the parties have worked hard to make sure they're satisfying a Stark exception, which often means satisfying regulations that have been issued by the federal government fairly recently in great detail, I think that tends to show a compliant mindset and a desire to be on the right side of the law. And that mindset actually does help on the kickback statute, because on the kickback statute, intent matters a great deal. And if you can show that you're pure of heart, that goes a long way to putting to rest any kickback concerns. So that's always the order of operations when I'm looking at an arrangement. Well, we talked a little bit about some of the flexibilities, the ability to go 90 days without collecting a signature, et cetera. How do you view those flexibilities in terms of the way clients put together their compliance process? In other words, do those new flexibilities allow a client to establish policies for contracting with physicians that say, hey, you got up to 90 days to write this thing up and sign it, Do they sort of build that into the process, or do they hold that kind of back as, we have it if we need it, but our policy is still that you're supposed to write up the agreement and sign it before you start performing services and sending money out?
Yeah, it's a good question. In my experience, many of the clients I work hold those in reserve. I mean, it is something to think about when you write a policy. Um, I think it's important to incorporate some best practices into your policy, but also make sure that the individuals implementing the policy are viewing it as a policy. Sometimes I see policies are drafted that they mention that their purpose is to comply with the Stark Law, but almost state that if you don't do it exactly by the policy, you have a Stark violation. And I think that's a little dangerous. I think a policy is an attempt to have a contract process that's going to be defensible under the law. But I think educating your people as to the policy is what we think are some best practices, and that if we don't follow the policy to a T, maybe we take the variance to compliance, and they have some discretion as to how this policy is ultimately implemented, is a way to sort of thread the needle here and avoid confusion. I would rather have, if individuals don't get the contract signed, in your example, Charles, and they get this contract signed 60 days after the date it's implemented, we know that's not a Stark violation. And I don't want someone running, raising concerns within the organization that we have a Stark violation. I would rather have them say, hey, we aren't following the policy here. We need to understand and then resolve that. And of course, the conclusion would be we don't have a Stark violation, in that example. So most organizations, I think, are holding some of these concepts in reserve. It would be very difficult to have a process where a contract isn't written or signed for 90 days after the arrangement is entered. It would be confusing, difficult to implement, difficult to audit. Most organizations are going to want their contracts to be reduced to a single writing instead of relying on a collection of documents, which is available under the Stark regulations. Similarly, even though the employment exception does not have a writing or signature requirement, most organizations are going to just still require that just for good contracting. And if they ever have some type of litigation down the road, they may want to have that signature in place as well. So I think what's really important for people to understand is that just failure to follow your policy does not equate to a Stark violation. Perhaps have it trigger a review by counsel or compliance. And then maybe ultimately, if that additional steps taken, you'll get comfortable and be able to document why it's okay under the Stark regulations. To me, that's the perfect cadence for a potential Stark issue, rather than have it all, be more rigidly viewed from my perspective.
Yeah, I agree with that, Joe. And I often suggest you actually put that right in the compliance policy. You say, we have standards that are stricter than what the law requires, to make it clear to people that you are holding yourself to a higher standard than you need to. But if you fall short of your own high standards, it could be a violation of the compliance policy, but not a violation of the law, as you just pointed out.
Yeah, and I think just adding on, I think we all can recognize that coming to a conclusion that's a violation of the Stark Law is not something that can be accomplished in just a written policy. That is we're acknowledging all this complexity. Right. The Charles, I touched on it before in the most recent Stark changes. The government, CMS, reformed the big three: fair market value, commercial reasonableness, and the prohibition on taking into account referrals. They tried to make the standards more objective. Do you think that was a successful effort?
I do think it was successful in the sense that I think that the standards that they have come up with now are more objective and are cleaner and clearer. There's no such thing, of course, as perfect, definitions or perfect regulations, and there's still room for people to argue and there's still room for confusion, but they've done a good job, I think, of separating them out. There used to be a commentary years ago that said that if compensation, even if it was a flat periodic monthly compensation, was above fair market value or inflated because of the physician's referrals to the organization, that could be viewed as compensation that took referrals into account. And, that was confusing for people because they thought, well, we get it. If it's inflated and it's not fair market value, okay, you failed to satisfy the fair market value requirement. So you've failed one of the big three. As Joe mentioned, these are the big three requirements that are embedded in almost all the compensation exceptions. And so if the compensation is not fair market value, you already have failed to meet the STARC. But by throwing in the idea that you also might be taking the volume or value of referrals into account, even though it was a flat monthly comp, I think that may have muddied the waters a little bit. And CMS has tried to, I think, move away from that. And while not explicitly disavowing that earlier statement, they've really sort of clarified that, look, fair market value is fair market value. You're paying within the range of what's marketplace fair market value. But a compensation taking volume or value of referrals into account is something different. Now you're talking about a formula where the compensation fluctuates based on referrals. So the more referrals, the more compensation there is. And you actually have to have a methodology that has referrals embedded in it in order to be considered to have compensation that takes the volume or value of referrals into account. And I think that's helped to try to clear up some of the analysis that we do. So I do think that's been helpful. Another area where CMS has made some reforms in an effort to kind of add clarity, Joe, this is a question for you, is in the world of indirect compensation arrangements. We haven't really talked about that much yet, but this is one of the things that makes STARC confusing. There's direct compensation arrangements, between the referring doc and the entity that performs designated health services. And then there's indirect. And indirect, can involve analyzing a string of financial relationships between different entities. And there's a complicated definition of when an indirect compensation arrangement exists. And then if it does, a correspondingly complicated exception for whether or not that indirect compensation arrangement is okay under STARC. So Joe, I'd be interested to hear how your thoughts on how sort of some of those changes have impacted, the parties and impacted the way that you analyze STARC issues.
Yeah, thanks, Charles. This is if you're talking about STARC being complex, this is the next level of complexity when you start getting into the indirect analysis. I would say just kind of you asked how does it impacted how I perform STARC analysis. We're applying a slightly different test, and are fewer arrangements falling under STARC because of this narrower interpretation of indirect? My answer would be yes. If you historically look at this test, the government said you can't follow every linkage in a chain down the indirect. So the test has always been, do you have an unbroken chain of financial arrangements? If yes, then does aggregate compensation to the physician in the closest non-ownership linkage in the chain vary with the volume or value of referrals? And so that's an important piece of the test. And then third, does the entity furnishing that the DHS have actual knowledge that the physician receives that aggregate compensation that varies with referrals? So that was the test historically. It's a subtle change to most, but to STARC attorneys, it was a big deal. The government said the new test is unbroken chain. When you get to that second part of the test, the compensation needs to not only vary with referrals to the entity, but also must be either not at fair market value, must include referrals to the entity as a variable in the compensation formula that positively correlates with the referrals. And so the test there got narrower, and so fewer of the arrangements are going to trigger an indirect the definitional analysis. And that's what CMS said. Even when you've heard CMS people talking about this, they were saying there's going to be fewer arrangements that trigger this because of that extra step in the test. So again, it gets very granular, but if you have an indirect analysis, it's important to step through, that additional piece that the government built into the most recent STARG regulations. Charles, we covered a lot of ground here. Thank you so much for being on our podcast. Thanks for the next iteration of the book. Just as a final thought, do you have any other trends of under STARG we should be aware of? Do you have any final remarks for our audience?
Just one other thing. We haven't really talked about self-disclosures. So if you do discover that you have a STARG violation, that typically means that the entity has gotten referrals from a physician that shouldn't have been referrals of designated health services, and they billed for it. They find out they have an overpayment, and there's a process called the SRDP, Self-Referral Disclosure Protocol, that you can use to go to CMS and self-report a STARG violation. And one thing to let people know about, I think it's a very favorable process. People are frightened to go to CMS, with their violations, and my experience has been pretty favorable. It hasn't typically triggered any big bad investigation of any other type, and typically the settlements are 5 to 10 cents on the dollar of Medicare collections, which is very favorable. And one last statement about that: they traditionally CMS has been very backed up. They've had hundreds of self-disclosures over the years, and sometimes it takes them years to get to one and to propose the settlement back to the self-disclosure. But they are starting to catch up a little bit. So that's the good news for those who are, who have ants in their pants and really want to settle up with CMS as quickly as possible. CMS is starting to work its way through the backlog, and self-disclosures that are being made. They will get to them a little bit faster than traditionally they did.
Agree. Well, thank you, Charles. Thanks to everyone for tuning in to today's podcast. Watch for content that is emerging and that we're producing right now within the Fraud and Abuse Practice Group. Coming up next month, we will be having a webinar titled OIG Compliance Program Guidance Reboot, What the Healthcare Industry Should Know. Charles and I didn't touch on that, but some really important OIG guidance came out in November of 2023. Really important for all healthcare organizations to be looking into that and understand that the components of the new guidance. So watch for that webinar. If you're looking to get involved in the American Health Law Association, if you're looking to get involved in the Fraud and Abuse Practice Group, you can reach out to me on LinkedIn. You can give me an email at jwolfe@hallrender.com. We'd love to find a way to get you involved. Charles, thank you so much for your time today. And again, thanks to everyone for listening in.
Thanks, everyone.